Rahsaan Hall, Racial Justice Director of the ACLU, doesn't need much introduction for most of you. But this is what we're talking about in terms of changing policies and practices, changing how the work is done. We're particularly focusing on district attorneys because prosecutors have such enormous impact on what actually happens, and how they do their jobs makes such a difference. So.
Thank you so much, Lori. Good afternoon, everyone. Added bonus. Thank you all. You have to excuse me fighting off a cold, but I wouldn't miss this opportunity. One, to be here to celebrate the work of this mass incarceration working group. You've done so much, and it's so important to have your voice in this struggle. So thank you for all that you have contributed to this. But then two, to spread the word about this campaign that we are involved in, and the mass incarceration working group of this body is a partner organization, as are many of the organizations in this room: EPICA, Greater Boston Interfaith Organization, NAACP, Families for Justice as Healing, the Massachusetts Bail Fund, the Criminal Justice Policy Coalition, there's a long list, but here, you know what I'm gonna do so I don't forget anybody and don't nobody get mad. There's this yellow sheet of paper in the back on one of the tables. Make sure you grab this on your way out. The name of the campaign, well, let me do this first. My name is Rahsaan Hall. I'm the director of the Racial Justice Program for the ACLU of Massachusetts. I'd also like to acknowledge my co-laborer in this work of criminal law reform, my wife, Trinette Hall. A lot of the work that I do, and she helps keep me grounded in this work. She's a social worker, clinician working in a locked juvenile detention facility. And so she brings a wholeness and a perspective to that work, to these young boys who are in this facility. And the stories that I hear about, to the extent that she can talk about some of these things, are very compelling and talk about the need for reform. And we are also blessed to have amazing young people in our lives who come to us through our church family. And so Brittany is one of our church family children that we take and love, and we're just so proud of her and all of the amazing work that she does, and has a tremendous heart for young people. So Brittany is with us, and she's joined us today. So prior to my work at the ACLU of Massachusetts, I used to be a prosecutor. I served in Suffolk County DA's office for 8 years. And I started out in the district court in Dorchester, and then got promoted to work in Superior Court and handled gang, drug, and homicide cases. And I saw a lot in those 8 years, and I was responsible for doing a lot in those 8 years. And when I left the DA's office, I went to the Lawyers Committee for Civil Rights, and then really got engaged in criminal law reform. And I say criminal law or criminal law reform or the criminal legal system because I struggle with the use of the term justice because of the absence of justice for so many in this system. And so in doing that work, I got some greater insight beyond what my own personal experience was and beyond what the experience of family members were about the role of prosecutor. A lot of people have read Michelle Alexander's book, The New Jim Crow, and looks at mass incarceration and the role of the war on drugs or the war against drugs as a significant factor in contributing to the increase in mass incarceration. But there's another book that I would recommend if you haven't read it. It's called Locked In by John Pfaff. And it takes an economic analysis of the criminal legal system from beginning to end, or from many different aspects. And he identifies several things as the cause of mass incarceration. And one of those things that he specifically points out is the role of prosecutors, because over the years, prosecutors have received more and more power. They've had more and more power to charge people with offenses, greater power to increase the sentences that get recommended, and ultimately the use of mandatory minimums that they use to leverage sentences and guilty pleas out of people. District attorneys are some of the most powerful people in the criminal legal system that barely anybody knows about or talks about. And so the name of this campaign is called "What a Difference a DA Makes." And every time I say that, I tell people I fight so much not to break out into song. Dinah Washington. But we need to recognize what a difference a DA makes. We did some polling because we felt, as the ACLU, we believe these things and we understand that they play a significant role, but what does the general public think about them? And so we polled, and we took a statistically significant poll of Massachusetts voters, and we found out that 4 in 10 Massachusetts voters, not residents, voters, these are people that go to the polls and vote on a regular basis, self-identified, 4 in 10 did not know that the district attorney is an elected official. This is someone that has power over charging decisions and bail requests and sentencing recommendations and what type of discovery gets turned over and whether or not they stand for or against any types of criminal law reform. And only 4 in 10 voters don't know that they are elected officials and that they are accountable only to the voters. Because we have a county governance system for the district attorneys, there's no governance structure that supervises them. But here's the thing, because people say, well, you vote for the district attorney and that's the accountability measure. In the last 20 years, 77% of DA races have been uncontested. So that's a problem if we're saying that the accountability measure is the voting public, but if the voting public does not have a choice in who is being elected to this role, then there's an absence of conversation. There is an absence of insight. And because district attorneys are overwhelmingly incumbents and because they're not called to account in the public a lot of times, the policies and practices of those offices get overlooked. And so with this campaign, one of the things that we're trying to do is raise awareness. This is a public education campaign. And so we have a website. It's www.dadifference.org. And we encourage everyone to go to the website to sign up to get alerts and information about what's going on, and also to sign up to be a volunteer. Since we launched in December, we've had over 300 people sign up to be volunteers on this campaign. And you say, well, what does the campaign do? Well, here's what the campaign does. In addition to raising awareness about what district attorneys are, we're going to have explainers and letters to the editors and op-eds and blogs and instructional videos or explainer videos about the different roles and aspects of prosecutors. We're also going to have canvassing. We're going to go out and knock on the doors of people who are self-identified as voters and tell them about what the power and the role and the influence of district attorneys is. But what's key element in this campaign is centering and prioritizing the voices and lives of those most directly impacted by the criminal legal system. And so we have set aside money to pay canvassers who are formerly incarcerated, because those are the folks who need to get out and tell their story and let people know how district attorneys' decisions and choices have impacted their lives. We're also going to host candidate forums. There are 14 counties in Massachusetts. There are 11 district attorneys because some of those counties are combined. And out of all of 11, right now there are only 2 contested races. Here in Middlesex, the sitting DA, as I'm sure many of you all know, is Marion Ryan. She has a challenger named Donna Padalano, who's a former prosecutor, former colleague of mine from Suffolk County, but also served as a defense attorney. And then in Worcester County, there is the sitting DA is Joe Early, and I'm drawing a blank on the challenger's name. I want to say Blake Rubin, but that might not be right. That is it, Blake Rubin? Okay. And so there's a challenger there. We're hearing strong rumors about a challenger out of Suffolk County. We'll see what happens. Yeah. I guess that's a testament to what people think of the sitting DA, Dan Conley. And we're hearing some hopeful rumors about a challenger in Plymouth County, where the sitting DA is Ted Cruz. I do live in Plymouth County, and my wife and I have talked it over, and I have decided not to run for this election. But that said, there will be candidate forums to hear from the candidates about what their policy positions are. What are their training practices that they have? Where do they stand on criminal law reform? And so again, I mentioned all of the instances within the criminal legal system where DAs have power and influence that people rarely talk about, from the charging decisions. And so folks will say, well, the DAs don't have any role in charging because that's the police, right? They're the ones that go out and make the arrest and then go to court and fill out the application for complaint and submit it to the clerk. And then the clerk decides whether or not to issue the complaint. This is true. But once that comes into court, who decides whether or not it's going to go forward or not? It's the DA's office. They can dismiss those cases right at arraignment. They can divert those cases to treatment. But instead, usually what I've found, what I recall from my years as a prosecutor, is we just take it. Whatever comes to us, we're not reevaluating it. And so one of the other things that's important is because most of the time when we see the district attorneys, the conversation is on the media about murders and rapes and sex trafficking and gun trafficking. And those are very significant and important cases that need to be handled. But an overwhelming majority of the cases that come through the courts are in district court, and they are low-level offenses. The Massachusetts Bail Fund, I don't know if anybody's a volunteer for the Mass Bail Fund, but essentially they are engaged in bailing people out who are held on bail under $500. And so since 2013, they've bailed out close to 1,000 people. And again, yes, that's applause worthy. And in that period of time of bailing people out who are held on bails less than $500, and again, we understand the implications and consequences of bail. If you're held, you can lose your job, you can lose your housing, you can lose custody of your children, just because sometimes you're too poor to afford bail. But in the nearly 1,000 people that they've bailed out, 49% of those cases have been dismissed. These are decisions that prosecutors are making that probably could have been made beforehand. And so this is a place where we ask, what is the role of the district attorney in those cases? The let me change that, the drug lab scandal. Massachusetts is home to two of the largest drug laboratory scandals in the history of this country. The Hinton lab and the Amherst lab. In the Hinton lab, 21,000 cases have been dismissed because of flawed or tainted evidence that was used in obtaining the convictions. And there's possibly another 8,000 that are coming from the Amherst drug laboratory. The district attorney's role is to fight for and pursue justice. In this particular case, their role that they took on themselves was to defend tainted convictions. We argued, the ACLU, along with the Committee for Public Counsel Service, argued from the outset to maintain the integrity of the system, right? No harm, no foul. Well, if there is harm, that's a foul. So for people to believe that the system actually works, when something wrong happens, there has to be some level of accountability. Just like we have the exclusionary rules. If police illegally seize evidence, that evidence can't be used in court. That helps us believe in the integrity of the system. So if a drug laboratory taints the evidence and it is tainted, you can't use that for a conviction, and any convictions that are obtained through that tainted evidence should be thrown out, so that we can continue to believe that the system works. But instead of agreeing with that and offering up the dismissals, they fought it for 5 years or 4 years until ultimately the court made the district attorney's office dismiss those cases. And so again, this is a role in a position of influence and power. And so lastly, well, two last things. Mandatory minimums. We talk a lot about the role of mandatory minimums. Mandatory minimums, as many of you I'm sure know, have given tremendous power to prosecutors. Myself, when I was a prosecutor, there was a young man who was charged with possession of Class D, marijuana, with intent to distribute within a certain distance of a park. He wasn't selling it, he just had a couple bags packaged like it was looking like he was going to sell it. No record, 18 years old. He brought into court, and because I was a prosecutor, we had specific instructions about what to do with school zone charges. The usual thing that we did, because every place in Suffolk County was either a school or a park, or within that distance, we would, if they had no record, we would dismiss the case, but we would only dismiss it if they agreed to the recommendation that we as prosecutors made. So for a 2-year mandatory minimum sentence, I said, I will dismiss the school zone portion if he agrees to take the sentence that I as the prosecutor recommend. And that sentence was a 2-year sentence, suspended for 2 years. So this 18-year-old man, no prior record, from all appearances seemed to be a good kid, had a 2-year House of Correction sentence hanging over his head for 2 years. I don't know what happened to that young man. I don't know if he had a probation officer that was a jerk. I don't know if he was riding along in a car with some wrong people at the wrong time and got stopped and that triggered a violation of his probation. I don't know if he successfully completed probation and went on to go to college. I have no clue. And now we are on the precipice of this emerging industry of marijuana, and the people who are going to reap the greatest benefits look nothing like that young man. And so again, that was the role and the power that I had as a prosecutor, to give him that sentence. And his mother said, yes, we'll take that, because she didn't want him to go to jail. And that's that power that I have. And so mandatory minimums are something that prosecutors use time and time again to leverage guilty pleas, because people don't want to face the lengthy sentences, the lengthy mandatory sentences that they would get if they went to trial. And then lastly, criminal law reform. It is usually the prosecutors who stand in opposition. We celebrated Senator Friedman and Senator Eldridge and Senator Brownsberger for the progressive Senate package that came out. Guess who spoke up against it? Massachusetts District Attorney Association. 9 out of the 11 said, these are the things that we oppose. Your district attorney, D.A. Ryan, did not sign on to that letter, and we applaud her for that. But here's the thing. Consensual sex between juveniles. That shouldn't be a crime. We may not want, We may not want young people to have sex at that early age, but we should not have a crime on the book that criminalizes a 16-year-old and a 14-year-old having sex together, if it is consensual. But the DA stood in opposition to that. Raising the felony threshold. Currently, if you steal anything that is over $250, that is a felony. The Senate bill proposed raising that felony threshold up to $1,500. The DAs opposed that. The DAs opposed repeal of mandatory minimums because they recognize that it is a tremendous tool for them. What they said in their statement is, we as district attorneys, every district attorney in Massachusetts opposes the use of mandatory minimums against low-level, nonviolent offenders. That's what they said. I have 2 cases and then I'm going to sit down. First case is out of Essex County. There's a man who was approached by an undercover state trooper who was feigning to be dope sick. And in the substance use community, people recognize that when somebody is dope sick, usually the best thing for them, or the thing that will help them in that moment, is to provide them more drugs. And sometimes that's what people do. And so this undercover state trooper approached this guy, said, I'm dope sick, will you buy me some drugs? Feeling compassion for him, he went and purchased some drugs and gave it to the man, to the state trooper, the undercover state trooper. They arrested him and charged him with distribution of heroin. That in of itself is not a mandatory minimum. But because this man had a 19-year-old prior conviction, they charged him with distribution class A subsequent offense that carried a mandatory minimum sentence. That is a low-level nonviolent offender, but yet they charged that mandatory minimum. Second case, out of Suffolk County, a young man who was sitting in the passenger seat of a car, drives past a park and is stopped by the police once they get past the park. He has drugs in his pocket that he has packaged in a way that is consistent with distribution. The police charged him with possession of a Class B substance, cocaine, with intent to distribute within 100 feet of a park. Not for selling drugs in the park, not for stopping and having that amount on him at the park, but being the passenger in a car driving past the park. Charged him with a mandatory minimum sentence. That's a low-level nonviolent offense. So we have to have a conversation about the role and the power and the influence of prosecutors. I encourage you to sign up for this website, www.dadifference.org. We're going to have a report card in the end of the summer so we can evaluate and see how the district attorneys are performing. Where do they stand on transparency? If you send a public records request to them, do they respond to it? How are they on racial justice? What do the demographics of the people they convict look like compared to the demographics of the people in their county? What do they do with civil asset forfeiture funds? Are they using that to reinvest in community prevention alternatives, or are they using that to stock up their reserves and stock up their cachet of money? These are the questions that we have, and these are the things that we are going to evaluate them on, because district attorneys have such power and influence that progressive DAs and progressive values could be held up to change the criminal legal system such that we might not even need criminal law reform if we had progressive DAs that take the stance to change and move us forward. So I welcome you to join us in this campaign. We need more volunteers. We really need to spread the word to raise the awareness. Thank you for your time and having me here.